Good afternoon. I'm Erin Nielson. I'm a family law attorney at Wilshams, Cosentino, and Nobbins. We're a full-service law firm with offices in Westford, Wellesley, and Boston. Today, I'm here to talk with one of my colleagues, John Donahue. John Donahue, hi, John. John is a estate planning attorney in our office, and he's somebody that we turn to from the domestic relations department when we have questions for our clients related to estate planning, to special needs planning. And today, John has agreed to talk to us about tax-related issues that come up for divorcing families. Thanks, John, for being here.
Well, thank you, Erin, for having me. And no, the collaboration goes both ways with help on prenups and postnups and separation agreement and people who are concerned about bond affidavits and things like that. It certainly goes both ways.
That is true. All right. So we're going to start out with some basic questions about tax that come up for a lot of our clients. And the first has to do with the tax filing status at the time of the divorce or while a divorce is pending. A lot of people wonder, should I file, even though I'm separated, should I file married filing separately, or should I continue to file jointly with my spouse? Are there any advantages or disadvantages either way?
You know, I would say that everything is a facts and circumstance, but I would say on a whole, once you get to the point of deciding to divorce, generally I would say that married filing separately makes the most sense. And part of that has to do with the ongoing liability that's associated with filing the tax returns. So when you file a tax return and jointly, you and your divorcing spouse are jointly and severally liable on that return. So to the extent that there are issues in the future, generally it's a better decision to start that separation process and file separately.
Well, that's an interesting perspective because a lot of times people are looking at sort of the short-term financial difference between married filing separately or filing jointly. Oftentimes, there's a tax benefit to filing jointly. So,
yeah, and I would say that one thing that depending on the parties, one of the things that someone who is thinking about filing separately might consider is whether or not they qualify as head of the household. So that's someone who is either they're actually divorced or separated, or they are considered to be divorced. And there are a couple different factors involved with living separately from the spouse and maintaining a property and having a qualified individual living in a property. So a lot of times if you have a divorcing couple with minor children, one of the spouses typically qualifies for that head of the household designation, so they get a little bit of a preferential treatment as opposed to filing separately. So again, facts and circumstances definitely worthwhile considering, looking at maybe the last 2 years and then how changing your tax filing status would affect the next coming year.
okay. Well, the other issue that you raised that was interesting was the question of liability. And sometimes we have clients who ask us about innocent spouse relief, or people who are concerned about income tax returns that have been filed in the past that may not have been 100% accurate. Can you explain innocent spouse relief and how that works?
Yeah, so again, when you have two spouses that end up signing a tax return, both spouses are jointly and severally liable. So to the extent that you have spouses that separate and one spouse does not, there might be a tax liability from a prior year. The IRS is ultimately going to go after either spouse, whoever will pay. There is relief between the spouses that can occur, but where innocent spouse comes in, it's one of 2 or 3 different options in which you can apply to have the government remove that joint and several liability. There is innocent spouse, there is separation liability, and I believe there's a catch-all equitable relief. So if you don't quite fit into one of the categories, you might qualify for equitable relief. And with any of these types of relief, they really hinge on the fact that it truly needs to be an innocent party, that it was something that the spouse, they may not have been intimately aware of the comings and goings, but they or a reasonable person would have had cause to ask questions and become aware.
So again, sounds very fact specific and like something you want to talk about with your own advisors. Is that right?
Yeah, and I would say to the extent that you have something like that pops up, I think that I think that there are a lot of things that come out as part of a divorce, and a lot of conversations, stories, and that it's certainly something that should be discussed either with tax professional or potentially separate counsel, in terms of not going back to the same tax preparer, but maybe you engage in a relationship with a different tax preparer to think about how that spouse is going to take steps forward to protect themselves long term.
Okay, and just generally, no matter what the reason, if parties own or owe tax debt together on jointly filed tax returns, or maybe they fail to file tax returns, it sounds like that debt is joint and several.
Yeah, so many times it's quite common to parse out that responsibility as part of the separation agreement, but ultimately the IRS will look to either party to satisfy, and to the extent that it was the responsibility of one party versus the other, once the IRS gets satisfied, it's up to the parties to deal with each other at that point. So, very important to make sure that if there are concerns that potentially getting a worst case scenario opinion from a tax professional as to what the potential liability might be out there, so the parties can be prepared.
Okay. So on a totally different topic, alimony. I know there have been some changes to the tax law with respect to alimony, and can you give us just a quick update on where that stands, both federally and at the state level in Massachusetts?
Yeah, so after January 1, 2019, any separation agreements that are entered into, the big change is that the alimony paid is not deductible by the payor, and it's not reportable as income for the payee or recipient. So, in some ways, this changes sometimes the calculation with divorcing parties, in terms of you may have a higher wage earner who may be would have been previously comfortable paying a higher alimony in order to get an income tax deduction. Post January 1, 2019, that deduction isn't available. So that might, I'm aware that influenced how a lot of people and practitioners view divorces, and even if you had a deal that was substantially complete towards the end of 2018, depending on if it benefited you or not, that might have been a motivation to finalize before the new law went into effect, or might have been a reason to potentially delay finalizing. And I think it's worthwhile that in any type of long-term separation agreement that periodically it's worthwhile to review the agreements, because with the different changes, it might be advantageous. Maybe you don't have the high income wage earner anymore, or maybe the other spouse has a different type of income. So it's certainly worthwhile to reevaluate it every couple of years, just to make sure that hopefully the parties are agreeing to an equitable agreement.
Right. Well, that makes sense, because, with respect to existing agreements, alimony remains deductible, correct?
Cool.
Or agreements that were entered into before December 31st of 2018?
Yeah. It does. So
but new agreements might change that, right?
correct. So certainly important to make sure that you're considering what the modifications are and what the scope of them are, to the extent you decide to make modifications at this point.
Right. Okay. So I'd like to move on now and talk a little bit about tax-related issues that come up in the division of marital assets.
Okay.
So, of course, one of the biggest assets that gets divided in a divorce is the marital home. Are there tax consequences to selling the marital home or to making a decision to keep the marital home that people should be thinking about?
Yeah. So, like any other asset, a home tends to be, a significant long-term capital asset, meaning significant that it usually makes up a big portion of the family's portfolio. Long-term meaning that you hold it for over a 12-month period. There's different types of income tax treatment to that. One of the important things that people run into is that, like any other asset, you buy something for $5, you sell it for $10, you have $5 of gain that you have to pay tax on. And usually with a married couple, when they're buying and selling their primary residence, they're able to avail themselves of their Section 121 capital gains tax exemption, meaning that a married couple can exempt up to $500,000 of gain. So a lot of married couples, when they go to sell their primary residence, don't end up paying capital gains tax because of that $500,000 exemption. Now, a single person is only able to avail themselves of a $250,000 exemption, which is still a good amount. But one thing to consider is that with the divorcing parties is, when did you buy the home? What did you buy it for? Because that's really where we start with our basis. And what are the long-term plans with respect to the home? Are we going to get a divorce and then a year later there'll be a sale of the home? And so potentially we should look at what the couple bought the property for, and the spouse that's going to retain ownership of that property, what their projected gain will be on the sale of that property, and whether that $250,000 exemption covers them or not. It's a less of a concern if it's going to be a long-term property for the family, but certainly something to consider. What's not only the division of assets, but what's the long-term plan with those assets? How long do couples intend to hold on to them?
Right. That could be a nasty surprise for somebody who thought they were going to keep the marital home and then decided to sell it a year or two later and was hit with the full capital gains tax.
Yeah, and maybe it's a motivation for the couple to sell the home prior to divorce, so you get the $500,000 exemption, and one spouse is able to take the equity and roll it over into another property.
And what about with stock? So oftentimes people own stock that gets divided between the parties at the time of the divorce. Should they be thinking about capital gains in that context also?
Yeah, I think of it again, a facts and circumstance. The home is certainly a significant asset, and so the biggest difference between the home and the stocks is that we don't get that capital gains tax exemption. So you bought the Apple stock for $5, it's now $10. There will be gain when that's sold. So part of the consideration should be is that after the division of assets, it's to what extent is the spouse going to need to tap into those assets? Is there going to be a sale in the near future? One other thing to consider is that to the extent there is any gifted property throughout generations, sometimes we have generous parents who, for one reason or another, decide to give that same stock to their kids. They've been holding on to it for a longer period of time. There might be much more greater gain baked into that asset. So I think part of it would be, to what extent, how long has the couple been holding on to this asset? How much has it appreciated? What's the plan with that asset post division of assets? Whether or not they're going to need to tap into it. So I think it plays a factor. I don't know if I don't know anecdotally if anyone has ever really picked and choose between the stock portfolio, that they wanted the AT&T stock versus the IBM stock because of the gain baked in there. But I think it's certainly something that should be on the table.
Yeah, that was the question I was just going to ask, which is if you have a large portfolio of stocks and some of them, were purchased at different times. Oftentimes people are just looking at the present day value, but maybe it's worth thinking about what the basis is and the gain and considering the tax issues. Yeah, if it's a large number of stocks.
I would say that, it's, I don't think that, it's how much time and effort needs to be put into it. But I think that if it's big enough, and most financial institutions are able to generate statements that have the basis on there, that if you, if you've got assets that have significant gain, that might impact not just the division between 60-40 of the portfolio, but what makes up that 60-40.
Right. Okay. Lots to think about. So the last topic I wanted to talk to you about is RSUs, restricted stock units. So more and more we're seeing our clients, either our clients or our client spouses, are receiving RSUs as part of their compensation packages. So can you generally explain what RSUs are, and then kind of give a sense for issues that we should be looking out for?
Sure. So RSUs, restricted stock units, tend to be part of, I think you might just mentioned, as part of compensation packages. So generally to reward either key employees or longtime employees. One of the important features about them tend to be is that they are subject to a vesting schedule. So for instance, that you have you have the rights to potentially have 100,000 shares, but they don't become fully vested until 3 years, 4 years, 5 years, and usually it's on a rolling scale, so that as the employee maintains employment with the company, they're entitled to have a bigger amount of shares. So one thing to probably consider is how big or how sophisticated the company is, because a lot of times within the shareholder agreements for those companies, there are oftentimes restrictions on the transferability of those shares, whether they're between spouses for very legitimate reasons. There are also usually some restrictions in terms of if there's a division or there's an order to transfer assets pursuant to a divorce. Sometimes they cause a liquidation event of those assets. So I think the biggest thing that I would say is that for the divorcing parties to get a handle on what exactly the asset is and what restrictions are they subject to. And going back to the first point, what it is that there's all different types of incentive stock, there are options, there are just plain restricted stock. So getting a better sense as to what the asset is and whether or not it's something that's real and tangible, that it's vested, and to what extent could the parties divide the assets easily. Because a lot of these closely held companies or smaller companies, they don't want strangers to be shareholders. They want employees to be shareholders. So they typically don't want the divorcing spouse to be a shareholder in the company. They want the employee. So that's why they bake in those restrictions.
But the RSUs themselves are not transferable, correct?
So it typically not. Typically they are limited to the individual themselves, and again, part of when employees are typically given those types of benefits, it's usually preferable to sit down with a tax professional just to understand what they are, because there are some beneficial tax elections that can be made when they receive that type of compensation. But typically, most companies are going to be subject to a restriction on the ability to be able to easily transfer those shares. And again, to the extent that the shares haven't vested, that's not something that can be transferred because they don't have the property rights yet.
So thinking about the income taxation angle, even if the parties agree that they're going to in some way divide those shares or the value of the shares once they're vested, if they remain in the employee's name, is there any way to shift the taxation to maybe the lower income spouse, or is it always going to be taxed at the income level of the spouse who holds the RSUs?
Yeah, so it'll ultimately be taxed at the rate of whoever owns it. So if it's something that can be transferred, then it would be potentially show up on that spouse's or ex-spouse's 1040 in the future. Again, one of the things that parties should probably do is try to figure out what it is, and there are reasons why there are certain tax elections that you can make when you initially receive the options, so that you can pay the income tax based on the value at the time you received it, as opposed to the value at the time in which they become fully vested. So there's some strategy involved in whether or not the parties believe that that's going to be an appreciating asset or not. I have anecdotally found that they are tough assets to really value because everyone anticipates the value to continue to increase over time, but the spouse that probably is, the spouse that's giving them up or trying to give them up, they usually want to value them fairly low because they're worth less at this point in time. So I don't know of too many people that have given the spouses those restricted stock units and they continue to hold them. They tend to end up with the spouse who's the employee of the company.
Right. Okay. Well, John, I'm so grateful that I have you to ask my questions of in the office, and I'm also so grateful that you were willing to answer some questions for me here today. So thank you.
I appreciate you having me on. Thanks so much.